Hi, I'm Debbie Moraes. Once again, this is Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and your work life. Today, we're going to discuss a topic that affects underage children. You, if you happen to be one, and your parents if you happen to have one. Specifically today, we're going to discuss wayward children, youth offenders, juvenile delinquents. Wayward children is considered a phrase that's been part of the Bible, but for you, if you happen to be part of the legal system, you might really care about what it means, what it does, and what kinds of consequences it might have for you. Once again, we welcome from Bazar, Grasso law firm in East Providence, Jackie Grasso and David Bazar. So let's get guidance from you. First off, what is the wayward child, the juvenile delinquent? How do you define it?
Want to start with that?
Yeah. Wayward child is a child that is, for the most part, disobedient, runaway child, a child where a parent really doesn't have much control. A truant child, truancy, meaning that they haven't been attending school. The major difference between a wayward child and a delinquent child is a delinquent child is a child who's actually committed a crime. Misdemeanor or felony, but with a wayward child, there's no crime involved. That's the major difference. And we have a family court in Rhode Island that deals with wayward children, and we have also a family court that deals with juvenile delinquents in a juvenile court. We have a juvenile court in Massachusetts that deals with juvenile delinquents and wayward children.
If you happen to be under the age of, is it 16, 17, 18, do you automatically in Rhode Island go to family court versus criminal court, or is it different in Rhode Island or Mass?
So in Rhode Island it changed with Craig Price. If you remember, he was the murderer at a young age, very young age. And it was his first offense. He hadn't been convicted of anything prior, so at that time they couldn't waive him from the family court to Superior Court to be treated as an adult, even though it was a heinous crime that he had committed. So the rules have been changed that you can be waived out of family court depending on the severity of the crime or your age or being a repeat offender. And then you're treated as an adult.
In Massachusetts, if you're 17 and you commit a crime, you're automatically charged as an adult. If you're under 17, then you have a similar hearing, which is like a waiver hearing before a judge, and if the crime is serious enough or heinous enough, then they'll transfer it over to the criminal court.
We also actually had one other additional situation in Rhode Island, which Jackie and I talked about before, the GAP kids, which we changed the law in Rhode Island so that you were treated as an adult at 17 instead of 18. And then they decided that that really was not a very good idea, so they changed it back. But in the meantime, there were a bunch of children who had been charged as adults, even though they were 17 at the time. And so that has all been worked through the system at this point, but it created some issues.
It was about 3 years ago,
Right.
4 years ago.
And what happens up until the age of your 18th birthday? If you committed the crime and it's still in the family court, those records sealed so that no one can ever know about them?
Anything concerning juvenile is sealed. Unless the child is charged as an adult, then it's a sealed record to preserve the child's ability to rehabilitate, confidentiality purposes. No one can attend a hearing other than the parties that are involved as well. It's a closed courtroom.
And remember this, the main difference between a juvenile system and the adult system is the juvenile system is to rehabilitate, and it's purely about rehabilitation. The adult system involves punishment. So we're not going to punish a child who's committed some stupid act as a child. We're going to give them that fresh start, let them turn their lives around. So that's part of the reason their records are confidential.
So you mentioned stupid things. Kids do stupid things, but they also, some of them, have done some very heinous, horrendous things. Murder. Even with murder, that record is sealed?
No, because the child, if they're tried as an adult,
which they might be.
If they're tried as an adult, then you get treated just like an adult would. I can't see a child charged with murder. Under a certain age it would have to be, but
it would be.
I mean, if it's a 6-year-old child,
right,
you're going to try a child as an adult. I mean, that's become an issue in other states.
Right.
But as long as it's not a crime and you're not charged as an adult, it's absolutely a sealed record.
Right. And again, going back to that a little bit, the child who is waived out of the system is treated as an adult, therefore they have the right to a jury trial. Remember, in family court for a juvenile case, even though it's a criminal case, since the purpose is rehabilitation, if there's a trial, it's in front of a judge, not a jury.
Okay, and if they have their records sealed and the state of Rhode Island wants to help and rehabilitate, there still are consequences for the child who does something very wrong. Let's talk about what those consequences are, and in particular, what happens to the child at school. We have read that there are times when, if not the teacher, perhaps it's the principal who might get involved in either suspending the child or expelling them, even if that crime, even if that behavior, bad behavior, wasn't on the school property. What has to happen? I know that it's not automatic that the principal can just say, you are in trouble, so also you're bounced out of school. Go through that
Right. So,
process.
If someone's charged as a juvenile and is brought through the court system, and it's such a bad crime that the judge feels that rehabilitation is needed at the training school, then they'll be moved to the training school. If the judge feels that, no, this child needs to be returned home, have some counseling, some other services put in place, usually the judge will say part of the deal is you're going to go to school. And if the judge orders that child to be in school, I think it would be very difficult for a principal to overrule the judge's decision that that child's going to be in school. If they want the child to be out of school, they have a right, the child has a right to a due process hearing, and then the city or town, wherever that child lives, has to provide educational services, perhaps in the home with tutors going in or some other services, because the child has a right to an education.
Constitutional rights, your fundamental right to an education.
And I understand that if the child happened to be a special needs child, even more difficult it is to remove him from that system.
Correct.
And even he or she deserves to be educated. The question is where and how, but nevertheless, if the principal or the teacher reports to the principal, Johnny is potentially dangerous, we're afraid for the rest of the school children. Obviously, we've read that there have been mass murders in the school system. If the teacher suspects that, worries about that, if the school counselor suspects that, worries about that, what happens? It goes to the principal, and the principal has to go to the judge? What happens?
Well, they would call the police department immediately, and then it's in the hands of the police department, and then they'll investigate, prosecute, whatever it is that they do, and ultimately, if they do find that there's a serious enough threat, they could be charged.
Right.
And then it goes over to the Attorney General's office in Mass, or the District Attorney's office, District Attorney in Mass, Attorney General in Rhode Island, to determine whether or not they're going to be prosecuted in juvenile court.
And if there are exigent circumstances, if there's some immediate information, the child's not going to get a due process hearing. The principal can immediately send the student home or have the police investigate and do whatever is necessary. It's not a situation where someone's had some bad behavior in school, for example, and has violated school rules, and now the principal really wants to expel that student for doing things at school. That's where the due process hearing is taking place, and there's some rights that need to be protected. There are rights that need to be protected in the first circumstances, but the rights of all the other students will take precedent.
At some point, if there is a judge involved and a court system involved, at what point does a lawyer potentially get involved? We've talked about times when someone could go online, look it up, and do it yourself. We encourage that when it's possible. When it's something like this, is it ever possible for a parent just to see this through, or is it feasible or necessary that we have a lawyer, and at what point do they plug into the system there?
If a child is being charged as an adult, of course, you have an automatic right to counsel. If the child's being charged of a crime, a child's delinquent, meaning he or she has been charged with a crime, then same thing, he or she has an automatic right to counsel. So either they can hire a private lawyer or they can have one appointed from the courts. If it's a wayward child who is in front of a judge because of delinquency issues or whatever it is, then the child has a right to counsel. They may appoint a special advocate for that child. We have CASA volunteers CASA attorneys in Rhode Island or guardian ad litem. But an attorney will represent the child, and the parents also have a right to counsel if the parents are being charged with abuse or neglect as well.
Right, now we're moving towards, in Rhode Island, DCYF type
Yes.
of cases, and if you can't control your child or your child is dependent on the state for services or some type of thing, then both the parent and the child are entitled to have their separate representation.
Let's talk about the parents now. You happen to be the parent of a child who not only misbehaves, because children misbehave and have to be brought in line. If you can't, or you really think that there's something seriously wrong and you want to, I don't want to say necessarily abdicate responsibility, but you just know that you cannot take care of this child and you want to petition to have the state do it. How does that process play out and what's involved?
In Massachusetts, it's called a CHINS petition, a child in need of services. It's for a wayward child who's been disobedient, who hasn't been attending school, who, just is way out of hand, runaway child as well. So you petition the court, ask the court to provide services to this child, and the court will get involved, DCYF gets involved. Parent can do that, or they can have the police department do that. And in Rhode Island, it's similar. It's not called a CHINS, but it's similar.
Right, a dependency petition or something of that nature where the child's not listening to anything that you say at home. So you would file through the court.
And if parents decide that they need to do this, reluctantly or whatever, does that give them a pass in terms of their obligation if the child does something that, they destroy the neighbor's property and there's some financial responsibility? If they decide to file a petition, do they end up getting a pass? Do they end up abdicating that responsibility, and also are they relieved of the consequences of making remuneration?
Parents are responsible for the acts of their child.
At all times?
Yes.
Not only they're responsible for the acts, and of course, there is some Rhode Island limitation on torts as far as a dollar amount that you might be liable for. But the parents are also responsible for the cost of caring for that child. They don't, if you're paying child support, for instance, in a divorce situation, just because DCYF is involved or something else doesn't relieve you of your financial obligation towards the child.
And in the medical situation, suppose it's not about bad behavior, but you just have a sick child and somehow you had understood that the state takes care of its children because they're bound and beholden to. Do parents end up waiving their rights to the child at times, nothing to do with a wayward child, but an ill child that they cannot financially underwrite the cost of any longer?
No, if the state is getting involved, it's because the child is on some state assistance, whether it be Right Care or Massachusetts Health, which is like a form of welfare, and the state provides the health care to the child at either a reasonable cost if the parents are making a living, or in some cases they don't pay for it at all. It just depends on the financial situation of the parents. And they have to have custody.
Medical issue is not a reason to bring DCYF into a case. In fact, DCYF may want to get involved in a case where they feel that the parents aren't making good decisions for a child. That's a very difficult area and something you try to stay away from. The area where DCYF or the state might become involved with a child isn't necessarily for medical situations, but for services that are needed, counseling services. I saw a case once where there was an overweight child who was already in DCYF care. You wouldn't put your child into DCYF care just because they're overweight, but since this child was already in care, the judge ordered DCYF to either investigate whether or not a scholarship would be available for the child at a YMCA or have this DCYF pay for YMCA.
Let's talk about the child that is delinquent or does something that's terribly wrong, and it might even be a crime. Parents often want to protect their children. Suppose they think that they can at least call the police because the police will shake the finger, admonish the child, and scare him into good behavior. I've read that may have unexpected consequences.
Well, the consequence would be that police would probably charge the child with a crime if there's a crime that was being committed. I said earlier, you just can't call the police because the child won't go to bed at a certain time. If it's serious enough, then the police are obligated to remove the child from the home. They can be charged with a crime. The child depending on, it just depends on the facts as to what happened.
So if a child has committed a crime or is committing a crime and you call the police, it's now in the police hands to decide whether or not they're going to charge that case and prosecute that case. And you can't say, no, I've changed my mind. I don't want you involved. Once they're involved, they determine what the extent of their involvement needs to be.
And that's the letter of the law, correct? If you happen to know police in your area because you are a good citizen and you just happen to know them, your child lifted something from a store, a toy that he should not have. Obviously, he doesn't need to be incarcerated, but having the police give the boy a talking to might have enough weight. Does that still make that a bad idea to call the police and have him intervene?
Not a bad idea, but every police department does have a juvenile officer, and maybe they have, it's possible, but you can utilize the services of a juvenile officer. Even the cities and towns have juvenile hearing boards as well. So maybe,
And
could end up there.
I have had situations and seen situations where there are really good, I think they used to call them DARE offices, I don't know if they still do, where they are in the schools, they know some of the kids, they know what's going on, and have been brought in to really talk to a particular child or student and get to the heart of some of the issues. So those situations and those officers who are really trained to deal with children are very good at that. So that I wouldn't hesitate to do. It's just to call dispatch and say, send over a police officer because I really can't control my kid. That's a little bit, you got to be...
Now it's out of your hands.
It's out of your hands.
Yeah.
If you had a child who was using substances and you then feared for your own safety or your spouse's safety, that's an appropriate situation, perhaps, that you call the police because you might need some serious intervention there. Is that also a point where the police will then decide whether or not that child needs to be removed, charged if he was not only using but selling drugs or who knows whatever else is happening? Is that also clearly an occasion where you would have to call the police, but it needs to be in their hands rather than the parents' hands?
Well, let's look at it from the liability of the parents. If a child has drugs in the home and the parent is aware of it, now the parent can also be prosecuted because they're aware of it. Yeah, I mean, the child can be prosecuted if they want to call the police. The police may decide, instead of charging that child, maybe have the child go before the drug court for rehabilitation, or maybe the juvenile board, hearing board in your city and town, so that you don't have the consequences of being deemed delinquent.
Rhode Island Family Court has, as Jackie called it, the drug court, which is designed to deal with issues of a child and drug abuse. And that actually, for a child who has that issue, is it's a very tough program, but it's a very good program. And if you get the child through that program, they end with no record. Of course, there wouldn't be a juvenile record anyway, but they're not even through the criminal side, so to speak, of the juvenile court. The thing is, as a parent, the first thing I would do is take my child to a professional and try to resolve the issue myself. That's how I would deal with it.
As a parent.
As a
now,
parent.
David, as the lawyer, if a parent called and asked you, what would be your suggestion or what would be your steering in that case? Still the same?
Are you able to deal with your child? Can you control your child? Can you make your child go to the appropriate counselors and get the appropriate help? If you can do that, then do that. If you can't, then bring on whatever services you need to help get that done.
File a petition for services.
If you need to.
Yeah.
And lastly, the other side of this, what about the child who already knows he done wrong? He did something wrong, he knows that he's in a bad situation, but clearly, as a child, she doesn't know how to get out of it. And perhaps he's thinking, part of the problem here is my parents, because parents sometimes are troubled, whether it's they're involved in their own bad behavior, or perhaps they too, alcohol, drugs, maybe they're convicted felons. What recourse, or what can a child do, underage child do? I'm not talking about emancipation there necessarily, but what do they do to make the situation right?
They can talk to the DARE officer at school, they can speak to a teacher, they can speak to a counselor. At that point, if an officer or any teacher, doctor, counselor believes that the child has been either abused or neglected, then they are mandated reporters, and they have to report it to DCYF immediately. DCYF has to immediately respond within 24 hours as to determine whether or not the parents have abused or neglected the child. There might be domestic violence going on in the home as well, and if there's domestic violence going on in the home and it's in front of a child, police respond, automatically DCYF becomes involved because it happened in front of a child.
It's the can'ts hotline, is that what
Yes.
they call it? The child could even call if the child was that concerned and wanted to get something done. But you can call anonymously as somebody who's concerned about somebody else's situation. I'm not a big fan of anonymous callers on anything. But as Jackie was saying, if the child tells certain medical providers, teachers, whatever, they are obligated to call.
And once, understandably, most children would be fearful of doing this. They don't know the system, they don't know who to call or what, but there are ways, you're saying, of that in the school system, perhaps helping them out. Of course, most children at all costs wouldn't want to be separated from their parents. They might
Right.
think that they're going to be yanked from them home, never see mommy and daddy again, and that would be terrible. So you're saying that there certainly are things along the lines that can be helpful to the child, and that they're not likely to do that as a first step. That's a court of
Yeah.
last resort. With lawyers that might be involved, when there is a situation with the child thinking that he needs one because there's maybe the parent brought a petition and said, I don't want to be involved with this child because he's doing bad things and I don't want to have any more responsibility, the court should take care of him. Is there ever a situation where a lawyer would represent the parents and a different lawyer would represent the child?
If it's an abuse and neglect petition against the parent, then they have an automatic right of counsel, just like they would if they're being charged with a crime. If there is a child involved, of course there would be a child involved, that child also has an automatic right to counsel. So the lawyers represent not only the child, they'll have another lawyer represent the parents.
Yeah, the child has a guardian ad litem appointed for them, and the guardian ad litem writes reports to the judge, meets with the child, and is supposed to advocate for the child's best interest. And sometimes what happens in these situations is the parents and maybe DCYF really want to see the child go down a certain path counseling-wise or service-wise. The child may have reasons not to want to do that, and the guardian's supposed to advocate what those reasons are, and the judge has to make decisions sometimes where the parents and the child are not on the same page, or DCYF and the child are not on the same page.
This could be a lengthy process, perhaps. Someone's watching or checking in, whether it's the guardian or the CASA volunteer, at some cases where you say that might happen. If there are frequent returns to have those reports reviewed, it's done at a court system?
Every time the court marks the case for review, which in these types of cases where DCYF is involved, even CHIN's petitions, they're going to review it frequently, and every time you return to court, the guardian ad litem or the attorney for the child, maybe the same person, has to file a report with the court as to the status of the child or if there's any progress. DCYF also has to file a report every time they return to court as well. So the judge, again, with the goal of reunification, that's the ultimate goal, is to reunify a child with the parents, not to take the child away from the parents. So it frequently will get marked for review. But if it's an abuse and neglect petition, you're being charged with a crime, and you go through the same due process that you would if you were in district court or in Superior Court.
Right.
You have a right to counsel and a right to be heard.
Let's talk about money. These visits to courts with lawyers, obviously lawyers are charging unless it's a public defender. What kinds of costs are taking place over in the state of Rhode Island if you were making, I don't know, could it be 3 years that someone was reviewing a case, 5 years? What kinds of costs are involved?
A
Must
lot
be
of
awful.
people would prefer to go with a private attorney for many reasons sometimes. And like any other situation we've talked about in the past, you can negotiate how your fee structure is going to be. Attorneys that do this type of work know how often they're going to have to return back to court and what it's going to take for them to do the work. So they might be willing to do a flat fee on that type of situation, which would be, this is what I'll charge you to handle this case from start to end, and that way the person might know exactly what it's going to cost. If you're doing it hourly, you really can't control it because you don't know exactly how many return visits there are going to be to court and how long it's going to take to get through the process.
And if it's a court appointed because you can't afford a lawyer, of course it's paid for by the
Yeah.
state.
And here's why you get court appointed, because there's public defender that could represent you, but there are sometimes two parents on different sides of the ledger here. And the public defender's office may represent one, that's a conflict for the other, so the court will appoint an attorney from a list of approved attorneys that will take court-appointed cases.
If the parents are in opposition about what needs to happen and that somehow impacts on the case, suppose the child really doesn't or disagrees with what the judge's outcome is. Does the child have any recourse? That what the child felt that wasn't right, that wasn't the right wouldn't say disposition. That wasn't the right decision, that shouldn't turned out that way. They didn't know, they didn't understand, and it's because of my parents or because of whatever else. Does the child have any recourse?
Child has the same recourse as the parents. The child has an attorney.
Has a right to be heard.
The attorney can ask for a hearing if it's a case that requires a hearing, or if the decision's been made, there's an appeal process.
And a parent, if they're going through this once with a child, bad behavior, a second time, a third time, is there any 3 strikes you're out situation that pertains to kids, or is it just because they're underage that it can go on endlessly until they turn?
There's no 3 strike you're out rule, but if I'm assuming you're talking about a wayward child.
Yes.
So, no, there's no. If it becomes bad enough, at some point, maybe the state could take custody from the parents.
Physical custody, you're
Yeah,
speaking
physical
of.
custody. The child can be placed either with another relative in the family, a guardian, or in state care, where the child may be placed in a
Group
foster home or a group home, same type of thing.
The 3 strikes and you're out usually refers to criminal cases. In federal court, they have, the 3 strikes and you're a habitual offender. 3 strikes and you're out in a criminal on the juvenile side would really apply to that waiver case situation that we talked about before.
Well, suppose this child is doing something annually that brings him into the court system. I imagine the judge knows the child very well at this, or somebody does, because he's habitual. You would want to turn that into something that might have more dire, I would think, more serious consequences, with the hopes of maybe averting something more serious when the child is now going to be. Would he ever go to adult court so that he would have more severe
they would have a
consequence?
transfer hearing or a waiver hearing, or they call it a certification hearing. If the child's charged with a crime, then the child can be charged as an adult. But before they can take the child from the family court jurisdiction into either the district court or superior court jurisdiction, they have to have a hearing. And the judge has to determine whether or not the crime is heinous enough to have this child charged as an adult.
Yeah, or that the child has been through the system so many times that at this point in time, this child needs to be treated as an adult. And there's a statute that talks about what goes into the waiver that the judge listens to, and he makes the determinations of the facts of, as it relates to this child and in this particular case, warrant being waived into the family court.
If there's annual events, and some are of the criminal nature, but some are related to maybe substance abuse issues, do those get weighed equally for a child? In other words, if they started doing drugs or experimenting and got into some trouble, but not the same as killing someone, stabbing someone, or breaking in, entering, or whatever, is that evaluated any differently?
Of course it is, with the goal, again, of rehabilitating the child. They may have the child referred to drug court, for instance.
Right.
Go through special drug abuse treatment programs. I don't know that it would warrant being treated as a child. It's just treated as an adult. Depends on the offense. If it's serious enough, it just depends on the offense.
The most interesting comment I ever saw on this situation was a child who asked a judge one time in a situation, you return the child back home after they go through the drug program? Yes. Well, do you think you've really fixed anything?
Really?
Yeah.
Well, we've had plenty to speak about. As this program ends, we would once again like to thank Jackie Grasso and David Bazar from Audette Bazar Cadero Grasso Law Firm in East Providence. We'd like to thank you for watching. Hopefully you're a little more aware and better prepared. We hope nothing happens to you or your children. We'll have the lawyers weigh in on our other issues as the discussion of legal matters continues, and we hope that you will join us.